A very good day, Professor. My name is Rajat, and my student ID is 1630264. In this assessment, we are going to talk about formation of contracts, key element and business implications. And now I am going to explain the essential element of contracts formation, that is intention to create legal relations. A crucial component of contract formation that establish whether the parties intend for the agreement to be legally binding in the intention to create legal relations. The existence of this aim separates commercial agreements which are assumed to have a legal intention from social and domestic agreements which are typically not enforceable under Australian contract law. The second one is legal framework and presumptions. Addressing the intention that established legalities, there are explicit presumption in Australian law. It is commonly believed that parties to a commercial agreement will need to be enforceable by law. If the situation suggests differently, this assumption can be refuted. Business implication. The goal to establish legal connection in business dealing has a big impact on enforceability, contractual duties, and negotiation. Business need to be clear about their goals, because if they are not, there may be disagreements about whether a contract really exists. The third one is risk mitigation. Businesses frequently incorporate language that expressly confirms about refuted the intention to establish legal connections in order to reduce legal risk. Thank you.
Good afternoon, Professor. My name is Chiren, student number 1570143. Let's talk about offer in contract law. In Australian contract law, an offer is crucial for forming a legal binding contract. It is a clear proposal from one party, the offerer, to another, the offee, indicating a willingness to enter into an agreement. For instance, if you say, I will sell my bike for $200, that's a clear offer. Your friend knows exactly what to decide. While in business, an offer sets the terms for agreements. If Company A offers 100 units to Company B at a specific price, it outlines the key elements of their potential deal. Besides, offer also guide negotiations.
Hi everyone, I hope you are doing well. My name is Zishan. My student ID number is 1633523. My presentation subject is Business Law, MCR009D. My presentation topic is Formation of Contract. Here I discuss about acceptance of contract, their rules, methods, and business implications of acceptance. Let's start with acceptance of contract. Acceptance of the contract. In contract law, acceptance is the unqualified agreement to the terms of an offer, transforming it into a legally binding contract. Acceptance rules are designed to ensure clarity and fairness in contract formation. First, acceptance must be based on an offer, as demonstrated in R.V. Clerk 1927, where the court held that Clerk's action made without knowledge of the reward offer did not constitute acceptance. Acceptance must also align strictly with the terms of an offer, as shown in Gilbert J. McCullough, Private Limited versus Pitt Club 1954, where a tenant's failure to meet specific lease terms resulted in the landlord denying the extension. Moreover, acceptance must be committed to the offerer. Silence alone is generally insufficient, as established in Felthos versus Bindley 1862, where the court ruled that an uncommitted intention to accept did not form a contract. However, acceptance can occur through a conduct, as in Brambles Holding Limited versus Bathurst City Council 2001, where the court found that continued service provision and payment acceptance signified acceptance by conduct. Now we discuss about method. The acceptance methods vary, including in writing, orally, or by conduct. The postal rule provides as exception acceptance occurs when a letter is posted, not when received, as seen in Adams versus Lindsay 1818. Business implications of acceptance. Acceptance is contract law carries significant business implications as it solidifies the terms of an agreement, imposing legal obligations on both parties. Business must carefully navigate the rules of acceptance to avoid unintended commitments and ensure the clarity in negotiation. For businesses, acceptance must strictly adhere to the offer's terms to prevent dispute in cases like Gilbert J. McCule Private Limited versus Pit Club 1954. Failure to comply with the specified terms led to a rejection of lease extension. In conclusion, acceptance is contract law impose significant obligations on businesses, requiring them to clarify, define terms and methods of acceptance and ensure that all parties communication intend effectively to avoid potential legal issues. Thank you so much.
Hi, my name is Gulfam Hussain, and today I will be presenting the subtopic of revocation of acceptance as a part of our group presentation on the formation of contract. In this part, I will explain how acceptance can be revoked before it becomes legally binding and discuss its legal principle and business implication. Revocation of acceptance refers to withdrawing an acceptance before the contract becomes legally binding. This can only happen if the acceptance has not yet been communicated to the offeror, meaning no binding contract has been formed. One key principle is that acceptance must be communicated to the offerer for it to become binding. In Adam vs. Lindsay 1818, the postal rule established that acceptance is effective once posted, which means revocation must happen before that letter is received by the offerer. In Falthos vs. Bindley 1862, the court ruled that silence cannot be treated as either acceptance of or revocation. Additionally, in Hyde vs. Ranch 1840, it was established that a counter offer effectively revokes any prior acceptance, showing that acceptance must be unqualified. In business, revocation can cause significant complications. Clear communication is crucial to avoid disputes, especially with digital or long distance contracts. To avoid ambiguity, business should specify in their contracts when acceptance becomes final and irrevocable. In conclusion, revocation of acceptance is possible until the acceptance is communicated. For business, it's essential to clearly define when acceptance becomes binding to ensure certainty in contracts and avoid misunderstandings.
Hello everyone, my name is Muhammad Zaid and today I will be discussing the role of consideration in the formation of contracts under Australian law. Consideration is one of the essential elements in contract law. It refers to the value that each party agrees to exchange as a part of the contract. This value could be money, services, or even a promise to refrain from doing something. Essentially, it ensures that the contract is not just a promise but a legally binding agreement. In the landmark case Dunlop versus Selfridge 1915, the court emphasized that there can be no contract without consideration. In another case, the Thomas versus Thomas 1842, court clarified that while consideration must exist, it doesn't have to be equal in value to the promise made. For example, in that case, a nominal payment of €1 per year was deemed sufficient consideration. There are two types of the consideration. Executed consideration is where the promise is performed at the time of contract is made, like when goods are delivered and payment is made immediately. Executory consideration is a promise to be fulfilled at a future date, such as agreeing to provide services next month in exchange for payment. In Chappell versus Nestle in 1960, even a chocolate wrappers were accepted as valid consideration because they formed part of the terms of the agreement. Similarly, in Australian Woolen Mills versus Commonwealth 1954, the court held that the indirect benefits can still count as a consideration, provided they are part of the agreed exchange. For businesses, consideration is vital because it makes contracts enforceable. In today's digital age, the Electronic Transaction Act 1999 ensures that electronic contracts, provided they meet all the essential elements, including consideration, are treated equally with the traditional paper-based agreements. In conclusion, consideration is fundamental to contract formation. Without it, contracts may be deemed unenforceable, putting businesses at risk. By understanding and applying the principles of consideration, businesses can create legally binding agreements that protect their interests while fostering trust in commercial relationships.